I'm Judge Christopher Wigand. I'm a family court judge here in Broward County, and I'm going to talk to you today about the mediation process. Are you about to attend mediation as part of your family law case? You might be wondering what mediation is, how it works, and what to expect. In this video, I will walk you through the key information you need to know to prepare for and participate in mediation. Whether it is a court-ordered mediation or a mediator agreed upon outside of the court system, understanding this process can help you feel more confident, informed, and ready to find resolutions to your case. Mediation is a process where two or more parties involved in a dispute meet with a neutral third party called a mediator. The mediator's job is to help you and the other party communicate and explore solutions, but they do not make decisions for you. The mediator's goal is to help the parties create their own resolution to the case. It is important to know that mediation is different from a trial where you appear before a judge, plead your case, and have the judge decide the outcome. You will not be appearing before a judge in mediation. It is an informal process. The mediator will not decide who is right or wrong. Instead, they help facilitate the discussion and help you and the other party identify mutually agreeable solutions. Only if you do not come to an agreement will you return to the court for the judge to make the final decision. If you agree on some issues and some are left unresolved after mediation, the judge will decide only those unresolved issues. So, what exactly is a mediator, and what does he or she do? The mediator is certified by the Florida Supreme Court and has taken training classes that specifically focus on issues relevant to family mediation, including family dynamics, parenting issues, and time sharing. The mediator is an impartial facilitator. They guide the discussion, help clarify issues, and may even meet with you privately in what's called a caucus to help move the process along. But remember, the mediator is not allowed to give legal advice or offer therapy. They're simply there to assist with communication and problem solving. The mediator is a neutral and impartial guide to help you come up with possible solutions, stay on track, and clarify areas of disagreement and agreement. The mediator may help you and the other party see the conflict from each other's point of view. Now, let's walk through what actually happens in a mediation session. The process typically starts with an introduction from the mediator, explaining their role in the process itself. The mediator will then invite each party to share their concerns and views on the dispute. If you have a lawyer with you, they might speak for you during this part. After everyone has had a chance to speak, the mediator may bring the parties together for a joint discussion or meet with each party separately in caucuses. Court-ordered mediation must begin with an introduction by the mediator explaining the process and the role of the mediator. Among other things, the mediator should explain the parties make the decisions, not the mediator. The mediator's introduction is usually followed by an opportunity for you and the other party to describe your concerns. If your lawyer is with you at mediation, these opening remarks may be made by you, your lawyer, or both of you. After these initial procedures, how the mediation is conducted varies. The mediator usually will meet with both parties together to discuss the issues to help you work out your differences. The mediator may also meet with each party privately. This private meeting is called a caucus. Generally, unless you give the mediator permission to repeat what you say in caucus, the mediator is prohibited from sharing what is discussed. If you are represented by a lawyer, you and your lawyer will decide how the two of you will interact during the mediation. Some lawyers instruct their clients not to talk during mediation. If this is your decision with your lawyer, it is fine. However, it is important for you to know that you are allowed to speak to the mediator at any time. Eventually, the mediation will end in one of three ways. Either one, the parties will reach an agreement as to some or all issues. All parties, and their lawyers if present, must sign the agreement. 2, the mediator declares an impasse because you, the other party, or both are unwilling to continue discussing resolution. Or 3, The mediator, with the parties' consent, continues the mediation session by adjourning for the day. If the mediator declares an impasse as to some or all issues, then you and the other party will have to go back to court to have the judge or jury, if there is one, decide your case. Preparation is key to a successful mediation. Here are some tips to help you prepare. First, try and obtain legal advice if you have questions. While the mediator cannot give you legal advice, an attorney can help you understand your case and advise you on what a reasonable settlement might look like. Organize your documents and any information related to the dispute. Being prepared will help you present your case clearly. Set goals for what you want to achieve in the mediation, but be flexible. New information might come up that affects your decision. Contact the mediation program or your selected mediator in advance and ask any questions that you might have. Also, make sure to arrive on time and arrange childcare if needed, as children are not allowed in the mediation room as well as court proceedings. Mediation provides an opportunity to talk with someone who is impartial. The issues in your dispute are not decided by someone else, self-determination. In mediation, you are the decision maker. The mediator helps you discuss your concerns, but cannot make decisions for you. What you say in mediation is confidential. Unlike trials and hearings, which are held in public courtrooms, mediations are private and, with a few exceptions, confidential. If your mediation is court-ordered or conducted by a certified mediator, there are laws and rules which require confidentiality. Information obtained during caucus, separate meetings with the parties, may not be revealed by the mediator to any other mediation participant without the consent of the disclosing party. However, a mediator may establish as a policy for the mediation that the information disclosed during caucus may be disclosed to the other mediation participants unless a party expressly tells the mediator to keep the information confidential. A signed mediated agreement is not confidential unless the parties agree it will be confidential and the law allows the agreement to be confidential. Instead, the agreement may, and in most family law cases, must be put in a court file. The mediator can help you overcome obstacles to communication with the other person or party in your dispute. Even if you have already tried to talk it out or negotiate with the other party, a mediator can help you and the other party listen to each other and keep you focused. A mediator is there to help both sides communicate and explore possible solutions. If you and the other party get stuck, the mediator can sometimes help restart the conversation in a new way and help everyone take another step forward. Mediation agreements are enforceable. If you reach an agreement in mediation, that agreement must be put into writing and signed by the parties. The written agreement becomes a legally binding document, a contract, which is enforceable by the court. A mediated agreement allows you and the other person or party to reach flexible solutions to your dispute. Mediation provides you with an opportunity to be creative with your solutions. If both sides agree, you can reach a settlement agreement specific to your individual needs. Mediation is different from litigation, a trial, where the judge or jury makes a final decision. With mediation, both sides can win. This is called a win-win situation. Mediation is not a trial nor an arbitration. In a trial, the parties present evidence and argument so a judge decides the outcome of the dispute. Likewise, in arbitration, the parties present evidence and arguments so an arbitrator or panel of arbitrators decides the outcome of a dispute. In mediation, the mediator assists the parties as they talk about their dispute to help them find and explore mutually acceptable resolution of their dispute. If you reach an agreement at mediation, you do not have to go to trial or arbitration. Mediation can save time and costs. Since mediation is a discussion between the parties, it can be much quicker than the formal trial process. Thus, it may also cost less than going to court in both dollars and stress. You know what you have agreed to in mediation instead of gambling with what the judge may decide if you go to court. If you resolve the dispute in mediation, you are not gambling on what the judge might decide. In a trial, the final decision will be made by the judge. It is uncertain what decision will be made at trial, but you will be bound by that decision whether you agree with or like the outcome of the trial. At mediation, the parties make the decisions. Mediation gives the parties control over the outcome of their own case by allowing them to come to a resolution with the assistance of a mediator to facilitate peaceful negotiations. Mediation is an opportunity to gain a greater understanding about why the dispute arose. In mediation, you are talking with each other, the mediator, and your attorney if you bring one. This interaction promotes a better understanding of the actions that led to the conflict. Sometimes, when the parties understand the why of the other person's actions, it helps create a desire to resolve the dispute. Once the mediation concludes, there are 3 possible outcomes: agreement or partial agreement. If both parties agree on some or all issues, the agreement is put in writing and signed by everyone involved. Impasse. If an agreement is not reached, the mediator will report this to the court, and you may need to return for a judge to decide. Adjournment. If necessary, the mediator may adjourn the session to continue it at a later time. Now, let's address some common questions about mediation. Do I need an attorney? No, you don't have to have an attorney at mediation, but it is helpful to have legal advice beforehand. How much does it cost? Mediation fees vary. Some court programs offer free mediation, while others charge based on income or the mediator's fee. How long does it take? Mediation can range from a few hours to a full day, depending on the complexity of the case. Mediation is a powerful tool that can help resolve disputes outside of the courtroom. It offers flexibility, confidentiality, and the opportunity for both parties to reach an agreement on their own terms. Whether you're looking to settle a small claim, family dispute, or business conflict, mediation provides a pathway toward resolution. Thank you for watching this guide to the family court mediation. For more information, you can visit the court's website shown on the screen below, where you will find resources, frequently asked questions, and more details to help you along the way. Good luck, and remember, mediation is an opportunity for you to take control of your dispute and find a solution that works for everyone involved.